The following DIRECTV stream terms of service and end-user license agreement can be found on the DIRECTV website at directv.com/legal/directv-stream-tos-eula-policy. There will be a link below in the video's description. DIRECTV stream terms of service and end-user license agreement, effective as of November 7, 2023, until replaced. This agreement applies to DIRECTV stream. For terms that apply to DIRECTV connected via satellite and DIRECTV connected via internet with equipment, visit directv.com/RTS. DIRECTV LLC licenses the app to you and grants you access to the service, conditioned upon your acceptance of these terms of service and end-user license agreement, the agreement. This agreement requires the use of arbitration on an individual basis to resolve disputes, rather than jury trials or class actions, see Section 10, and also limits the remedies available to you in the event of a dispute, see Section 12. By completing your order or by downloading, installing, or using the app or service, you agree: A. That you have read and understand this agreement and agree to its terms. B. That you are age of majority in your state or older. And C. To the DIRECTV video apps and device privacy policy. And D. Where applicable, to the DIRECTV privacy policy. Please carefully read this agreement, the DIRECTV video apps and device privacy policy, and the DIRECTV privacy policy to ensure that you understand each provision. In the event that we combine your information from the app with other data collected from your use of AT&T products and services that are covered by the AT&T privacy policy, the combined data will be governed by the DIRECTV video apps and device privacy policy. If you opted in or have been opted in to AT&T's Enhanced Relevant Advertising Program, and we combine your information from the app with other AT&T products and services, the DIRECTV Enhanced Relevant Advertising terms and conditions will also apply. If you do not accept these terms, please notify us immediately, and we will cancel your order or service subject to applicable cancellation terms and/or fees, Sections 4.6 through 4.8. If you instead decide to receive our service, it will mean that you accept these terms, and they will be legally binding. If a streaming device is available with your subscription to the service, as defined below, it is governed by its terms of use. If at any time after reviewing or using the app you wish to terminate such use or this agreement and cease data collection from this service, you must uninstall and remove the app from your devices and delete any copy of the app in your possession. For streaming devices that are supplied by or on behalf of DIRECTV, you must sign out of the app by going to Settings. You agree that information collected from you or your devices before you uninstall, remove, or cease to use the app can still be used. You understand that from time to time the app may differ based on which of your devices you are using to access the service, and that, as a result, the service-related features and functionality available through the app may differ from those available through the app on other devices. You also understand that this agreement will continue to apply to your use of the service even if the version of the app through which you access the service includes a different version of this agreement. Section 1. Definitions. A. DIRECTV, we, our, and us mean DIRECTV LLC and its subsidiaries, agents, employees, successors, and assigns. B. Service means the internet-delivered digital entertainment programming service known as DIRECTV or DIRECTV Stream. As such service may be rebranded from time to time. C. App means, other than any device software, the application for the service, any website, software, components, data, or services provided in connection with the service application and any updates to these items. D. Device software means any software that is preloaded on any service device that is supplied by or on behalf of DIRECTV and any updates to such software. And E. You and your mean an individual who downloads or uses the app and any person or entity represented by that individual. Section 2. The app. The app allows you to access the video programming we make available through the service collectively, content, by means of live television, by accessing content recorded at your request through the DVR function, defined below, and on a video-on-demand basis, in each case over a broadband or wireless internet connection. You understand that all content may not be available by each of these means. Section 2.1. Use of app. You must be 18 years of age, or the age of majority in your state or territory, to subscribe to the service. Individuals under the age of 18, or applicable age of majority, may utilize the app only with the involvement of a parent or legal guardian, under such person's service account and otherwise subject to this agreement. All use of the service under your service account, whether or not authorized by you, shall be deemed for your use. You are responsible for ensuring that all use of the service under your service account complies with this agreement. Section 2.2. Content. You understand that the service may include, and the app may allow you to access, content that may be considered offensive, indecent, explicit, or objectionable, and this content may or may not be identified as having explicit language or other objectionable attributes. We may make certain features, for example, parental control features, available to you through which you may attempt to limit access to certain content, but we do not guarantee that those features will be effective or, once we make them available, will continue to be available. Neither DIRECTV nor its licensors shall have liability to you for such content or such features. Content types, genres, categories, and descriptions, if any, are provided for your convenience, and neither DIRECTV nor its licensors guarantees their accuracy. Section 2.3. Limitation on streams and devices. The number of content programs you may concurrently stream at any given time is limited. The number of devices through which you may view those concurrent streams also is limited. The number of devices available for use in the simultaneous streams may change from time to time at our discretion. When you set a streaming device as part of accessing the service for the first time, the location at which you do so will be designated as the residential, non-mobile internet network with which your device is associated, home network. We may implement measures that restrict your ability to access the app for the service through certain devices, including those devices connected to your home network. For information on the current limitations that apply to the service, read the Device and Stream Limits Support article. For information on your home network, read the DIRECTV Stream Home Network Support article. Section 2.4. Video resolution. Resolution of video content can be affected by the format of the content we receive, the variety of internet connections and device screens used, and other reasons. So, while we can't guarantee a specific resolution, we use video optimization technology in an effort to provide a better experience, depending on the device being used and the bandwidth available. Section 2.5. Data usage. Usage of the app may count against your data usage, subject to the terms of agreement with your wireless or internet provider. Section 2.6. Geographic limitation. The service is intended only for individuals located in the United States, excluding Puerto Rico and U.S. Virgin Islands. You represent and warrant that, at any time you attempt to access the service, you will be located in the United States and will not attempt to access the service from any other location or through proxy servers located in any other location. We may use technologies to verify your geographic location and will block access to the service based on our good faith determination that you are located outside of the United States. Section 3. Free trials, subscriptions, pricing, billing, refunds, and cancellation. Section 3.1. Subscription packages. While we may offer content for free as part of a free view, the service may include different subscription packages for which payment of a subscription fee is required to access content available as part of those packages. You can find the specific details regarding your subscription package at any time by visiting Account Management for the service. Section 3.2. Free trials. We may offer free trials to the service to new customers. Unless otherwise stated in the terms of an offer, free trial offers are available to new customers only, are not available to customers who previously subscribed to the service, and are limited to one per customer. We may terminate a free trial for conduct that we determine in our sole and absolute discretion to be fraudulent or abusive. If your subscription to the service starts with a free trial, you must cancel prior to the end of the free trial, or your subscription will automatically renew for the price in effect at the time you enrolled in the free trial or the then prevailing rate. Section 3.3. Recurring subscription. Your subscription to the service will continue month to month until you cancel your subscription. or we terminated subscription. You must provide us with a current, valid, accepted method of payment method in order to subscribe to the service. For the service, we will charge your payment method monthly, on the same day you activate the service on your TV or the 15th day after you order the service, whichever is first. The day of your first monthly payment is your renewal date. For example, if your renewal date is on the 15th of October, we will charge your payment method on the 15th of each subsequent month. However, if your renewal date is on the 29th, 30th, or 31st in a given month, we will charge your payment method on the first day of the following month. For example, if your renewal date is on the 31st of October, we will charge your payment method for the following month on November 1st. If we attempt to charge your payment method on the renewal date and payment fails or is declined, then we may reattempt to charge your payment method one or more times within the following 30-day period. In these cases, we may, in our discretion, suspend or reduce your service to a minimum service level and change your renewal date to the day the payment is successful, if any. We may also contact you during the same period regarding the failed payments in an effort to ensure continued service. You agree to pay all fees and charges for the subscription, non-recurring charges, one-time purchases, taxes, fees, surcharges, and assessments applicable to the service, associated equipment, installation, and maintenance, and including all usage and other charges associated with your account. In order to provide you with the service, we may pay taxes, fees, and surcharges to municipalities and other governmental entities, which DIRECTV may pass on to you. If you reside in a property that provides the service to each resident, referred to as bulk programming, then we may disconnect, suspend, or terminate your bulk programming services and any upgrade or a la carte programming if your account is past due or not in good standing with DIRECTV. If the property-provided bulk programming services are disconnected, suspended, or terminated, then each individual subscriber's a la carte or upgrade packages may also be disconnected, suspended, or terminated. Section 3.4. DIRECTV Stream Term of Commitment and Early Termination Fee, ETF. The subscription to the service may have a 24-month term commitment for all new customers, term commitment. If you are within a term commitment and cancel your subscription to the service before you have completed your term commitment, you will be charged an ETF. We reserve the right to charge an ETF to the payment method you have on file with us. Depending on your acquisition date, the maximum ETF could be up to, prorated at per month over 24 months. So, for example, a new customer who cancels their subscription to the service after 14 months would be charged an ETF of up to a 24-month term commitment minus 14 months equals 10 months remaining times per month. Section 3.5. Cancellation/refunds. Subject to Section 3.4, you must cancel your subscription to the service before it renews each month in order to avoid charging of the next month's subscription fee to your payment method. However, as noted in Section 4.5, you will be charged an ETF if you are within a term commitment and cancel your subscription to the service before the end of your term commitment. You may cancel your subscription to the service within 14 days of purchase without paying an early termination fee. You may cancel your subscription to the service at any time by calling 1-833-622-0198. However, we do not provide refunds or credits for any partial month periods or unwatched content. If you cancel after your renewal date, you will continue to have access to the service through the end of your renewal cycle. Section 3.6. Payment methods. You will not receive a monthly bill. You authorize us to store your payment method information and to automatically charge your selected payment method monthly on your renewal date for your subscription to the service. You also authorize us to charge any one-time purchases, an ETF, installment payments, and other charges you may incur in connection with your use of the service to your payment method. You agree to update your payment method if there is change in the payment method information, such as account information or expiration date. DIRECTV can receive updated card information from the financial institution issuing the card. If a payment is not successfully settled due to insufficient funds, expiration of your payment method, inability to verify your payment method, or otherwise, your subscription to the service will cancel and will not auto-renew in accordance with Section 4.4. You can view your account information and payment activity online by logging in to here for the service with your user ID and password. Section 3.7. Fees. We may charge monthly recurring, transactional, and other fees that arise in specific circumstances only to those customers responsible for them. Additional information about the fees we charge is available at directv.com/legal/directv-stream-fee-schedule-policy fee schedule. This fee schedule is hereby incorporated into this agreement by reference. We reserve the right to assess additional fees or modify these fees, and you agree to pay the fees listed in the fee schedule. Section 3.8. Price changes. We reserve the right to adjust the pricing for the service, and any element thereof, in any manner and at any time, in our absolute and sole discretion. Except as otherwise provided in this agreement, any price changes to the service, or any element thereof, will take effect following notice to you at the email address registered with your service account. Section 3.9. Subscription limits. We reserve the right to establish policies from time to time intended to prevent theft, fraudulent activity, or unauthorized access to the service, such as restricting the number of subscriptions that can be associated with the same payment method, email address, or other identifying data. Without limiting our rights under Section 10 of this agreement, we may suspend or terminate your subscription and any other subscription with which we believe you are associated, with or without prior notice or other action by us, if we determine, in our sole and absolute discretion, that you have violated any such policies or have otherwise engaged in conduct we determine in our sole and absolute discretion to be fraudulent or abusive. We will not be liable to you or any third party for compensation, indemnity, or damages of any sort as a result of any such suspension or termination. And any such suspension or termination will be without prejudice to any other right or remedy we may have, now or in the future. Section 4. Account access and passwords. Section 4.1. Account owner. The person who created the service account and who agrees to this agreement is the account owner. Section 4.2. Direct access functionality. To provide you with ease of access to your service account, the service implements technology that enables us to recognize the account owner and anyone else who uses your service account, and provide the account owner and anyone else who uses your service account with direct access to your service account, including your viewing history, without retyping any password or other identification each time you and others who use your service account visit and use the service via the app, your streaming devices, or your browser. As the account owner, you are solely responsible for ensuring that other users do not access your service account through this functionality. Section 4.3. Access and passwords. You are responsible for maintaining the confidentiality of the password you use for your service account and are fully responsible for all activities that occur under your password and service account. You agree to keep your password confidential, not to share it with anyone else, and to immediately notify us of any unauthorized use of your service account. Section 5. Content and programming. Section 5.1. Programming. Many factors affect the availability, cost, and quality of programming. We reserve the unrestricted right to change, rearrange, add or delete our programming packages, the selections in those packages, our prices, and any service we offer, including the service, at any time. We will attempt to notify you of any changes within our reasonable control. Section 5.2. Pause live TV. The service may enable you to pause, rewind, and fast-forward live TV. If the Pause Live TV feature is available to your service, your acceptance of the terms of this agreement and use of the service constitutes your instruction to initiate recordings for supporting your use of the pause, rewind, and fast-forward functions. Section 5.3. Private viewing. The app and service are only for private, non-commercial use. Content may not be viewed in areas open to the public or in commercial establishments, even if no fee is charged for its viewing. You may not rebroadcast, transmit, or perform the content, or charge admission for its viewing, or transmit or distribute running accounts of it. You may not use any of our trademarks. Section 5.4. Blackouts. Certain programming, including sports events, may be blacked out in your local reception area. Blackout restrictions are decided by the sports leagues and other entities that own the local broadcast rights. Section 5.5. Nielsen. The app and service may interact with the Nielsen Company's Nielsen proprietary measurement software, which allows Nielsen to measure your content interactions in the app. Like Nielsen's TV ratings, this allows you to contribute to market research. You can learn more about your choices with regard to Nielsen measurement and how to opt out of having your content interactions measured by Nielsen by going to Settings in the app on your iOS devices, selecting About, and selecting Nielsen Measurement. Or by going to Settings on your Android devices, selecting Nielsen measurement, and clicking on the applicable link. If you are opting out, you must opt out on each of your devices. Section 6. License grant and use restrictions. Section 6.1. License grant. Subject to the restrictions set forth in Section 7.2, DIRECTV grants you a personal, revocable, non-exclusive, non-transferable, limited right to install and use a single instance of the app on a mobile device, streaming device, or other computing device that is owned and controlled by you, your device, and to access and use the app on your devices solely for accessing the service and viewing content, strictly in accordance with the terms and conditions of this agreement, in all applicable local, national, and international laws and regulations. Section 6.2. Restrictions on use. You shall not a. Decompile, reverse engineer, disassemble, attempt to derive the source code of, or decrypt the app for any purpose. B. Modify, adapt, improve, or create any derivative work from the app or content. C. Violate any applicable laws, rules, or regulations in connection with your access or use of the app or content. D. Remove, alter, or obscure any proprietary notice, including any notice of copyright or trademark of DIRECTV or its collaborators, suppliers, or licensors. E. Use the app or content in a manner that derives revenue directly from such use, or use the app for any other purpose for which it is not designed or intended. F. Enable the use of the app on a device that is not your device. G. Enable access to or use of content on a device that is not your device. H. Make the app or content available over a network or other environment permitting access or use by multiple devices or users at the same time. I. Use the app or content for creating a product, service, or software that is, directly or indirectly, competitive with or in any way a substitute for any services, product, or software offered by DIRECTV or its licensors. J. Use the app to send automated queries to any website or to send any unsolicited commercial email. K. Use any proprietary information or interfaces of DIRECTV or other intellectual property of DIRECTV in the design, development, manufacture, licensing, or distribution of any applications, accessories, or devices for use with the app. L. Circumvent, disable, or tamper with any security-related components or other protective measures applicable to the app or the content. M. Reproduce or archive content, except to the extent you elect to do so through the DVR function. Or N. Retransmit, distribute, sell, lease, rent, exchange, modify, broadcast, synchronize, publicly perform, publish, publicly display, make available to third parties, transfer, or circulate the app or content. You agree to abide by the rules and policies established from time to time by DIRECTV. Such rules and policies may include, for example, required or automated updates, modifications, and/or reinstallations of the app and obtaining available patches to address security, interoperability, or performance issues. These obligations survive termination of this agreement. Section 6.3. DVR function. The service may include functionality through which you can record certain content, the DVR function. You understand that DIRECTV does not guarantee the access to or recording of any particular program, or the length of time any particular recorded program may remain available for your viewing, and that the DVR function may differ based on your subscription. You also understand that content is the copyrighted material of the third party that supplies it, is protected by copyright and other applicable laws, and may not be reproduced, published, broadcast, rewritten, or redistributed without the written permission of the third party that supplied it, except to the extent allowed under the fair use provisions of the U.S. copyright laws or comparable provisions of foreign laws. You agree that DIRECTV will have no liability to you, or to anyone else who uses the DVR function, with regard to any content. DIRECTV may, at its discretion, and with or without notice to you, from time to time change, add or remove features of the DVR function or remove the DVR function in its entirety, and you agree that DIRECTV will have no liability to you, or to anyone else who uses the DVR function, with regard to any of the foregoing. Section 7. Intellectual property rights. Section 7.1. Rights to app and service. The app, including its source and object code, any copies thereof, whether or not present on your devices, the service, and all copyrights, patents, trademarks, trade secrets, and other intellectual property rights associated therewith are and shall remain the property of DIRECTV or its collaborators, licensors, or suppliers. The source and object code of the app are the proprietary and confidential information of DIRECTV and its collaborators, licensors, and suppliers. The app is licensed, not sold, to you. Title to the app and service shall remain with DIRECTV. DIRECTV and its collaborators, licensors, and suppliers reserve the right to change, suspend, terminate, remove, impose limits on the use of or access to, disable access to the app or service, or require the return of the app, or any copy thereof, at any time without notice and will have no liability for doing so. Except as expressly stated in this agreement, you are not granted any intellectual property rights in or to the app, service, or content by implication, estoppel, or other legal theory, and all rights in and to the app. Service and content not expressly granted in this agreement are hereby reserved and retained by DIRECTV. These obligations survive termination of this agreement. Section 7.2. DIRECTV marks. The following company names and their related logos and all related product and service names, design marks and slogans are trademarks and service marks owned by and used under license from DIRECTV, DIRECTV, and DIRECTV Stream. DIRECTV marks. You are not authorized to use the DIRECTV marks in any advertising, publicity, or in any other commercial manner without the prior written consent of DIRECTV, which may be withheld for any or no reason. These obligations survive termination of this agreement. Section 7.3. Open source software. The app may include third-party software that is subject to open source license terms, open source software. You acknowledge and agree that your right to use such open source software as part of the app is subject to and governed by the terms and conditions of any license applicable to the open source software, the open source license terms. In the event of a conflict between the terms of this agreement and the open source license terms, the open source license terms shall control. Section 8. No responsibility for third-party content and services. The app or service may permit access to products, services, websites, advertisements, and content from advertisers, publishers, vendors, and other third parties, third-party content and services. Your use of third-party content and services may be subject to additional terms of use and privacy policy set by the third parties. Your use of third-party content and services is at your sole risk and discretion. DIRECTV does not investigate, monitor, represent, endorse, or publish the third-party content and services. DIRECTV reserves the right to restrict or deny access to any third-party content and services otherwise accessible through the app or service. DIRECTV shall have no liability to you arising out of or in connection with your access to and use or misuse of the third-party content and services. Section 9. Term and termination. This agreement shall be effective until terminated. DIRECTV may, in its sole and absolute discretion, at any time and for any or no reason, disable the app, or suspend or terminate this agreement and the rights afforded to you hereunder, with or without prior notice or other action by DIRECTV. Upon the termination of this agreement, you shall cease all use of the app and uninstall the app from all devices, or for devices supplied by or on behalf of DIRECTV, sign out of the app by going to Settings, and delete any other copy of the app in your possession. DIRECTV will not be liable to you or any third party for compensation, indemnity, or damages of any sort as a result of terminating this agreement in accordance with its terms. And termination of this agreement will be without prejudice to any other right or remedy DIRECTV may have, now or in the future. These obligations survive termination of this agreement. Section 10. Dispute resolution. Please read this carefully. It affects your rights. A. Summary. We aim to make you happy as a customer, but if a dispute arises, DIRECTV and you agree to resolve it using the process described below. Read this provision carefully. It requires you and us to resolve disputes individually in binding arbitration or small claims court with limited exception and includes a waiver of class actions and jury trials. References in Section 10, Dispute Resolution, to DIRECTV include our past, present, and future parents, subsidiaries, affiliates, and related entities, as well as DIRECTV's and all those entities' officers, agents, employees, licensors, predecessors in interest, successors, and assigns. References in Section 10, Dispute Resolution, to you include your past, present, and future agents, heirs, successors, and assigns, and all authorized or unauthorized users or beneficiaries of our services or products under past, present, or future agreements between you and DIRECTV. B. DIRECTV and you agree to arbitrate most disputes. DIRECTV and you agree to arbitrate all disputes between you and us, except for claims arising from bodily injury or death. This agreement is to be broadly interpreted and includes claims that arose before this or any prior agreement between you and us, for example, advertising claims, and claims DIRECTV and you may have after you cancel your service. DIRECTV and you also agree to arbitrate claims relating in any way to us that either you or any users or beneficiaries of your DIRECTV service may have against our past, present, and future parents, subsidiaries, affiliates, employees, agents, or assigns. This arbitration agreement is governed by the Federal Arbitration Act. All issues are for the arbitrator to decide except for the following, which are for a court to decide. 1. Issues related to scope and enforceability of this Section 10 dispute resolution. 2. Whether a dispute can or must be brought in arbitration. 3. A dispute as to whether a claim is within the jurisdictional limits of small claims court. And 4. Whether Sections 10D, 10E, 10F, 10H, 10I have been complied with. Notwithstanding the foregoing, a party may seek monetary damages for noncompliance with Sections 10D, 10E, 10F in arbitration. C. Small claims court instead of arbitration is an option. Either DIRECTV or you can elect to have a claim heard in small claims court instead of arbitration, so long as the claim isn't removed or appealed to a court of general jurisdiction. D. Information required before beginning arbitration. Before you or DIRECTV start an arbitration, that person must first send the other a complete notice of dispute notice. A form notice containing all required information can be found at directv.com/arbitration-forms. Before arbitration can begin, all information requested in the form must be provided, whether you use the form or not, and the parties must comply with Section 10E, time to resolve the claim. You must mail the notice to DIRECTV LLC care of CT Corporation, 1209, Orange Street, Wilmington, Delaware 19801. If we want to bring an arbitration against you, we will mail the notice to you at your billing address on file. E. Time to resolve the claim. Whoever sends the notice must give the other 60 days from the date the notice is received to investigate and try to settle the claim. During the 60-day period, which can be extended by agreement, either you or DIRECTV may request a phone call or video conference to discuss individual resolution at a mutually agreeable time, which can be after the 60-day period. You and a DIRECTV representative must personally participate in this phone call or video conference, unless otherwise agreed in writing. You and our lawyers, if any, also can participate. Any applicable statute of limitations and contractual limitations period will be told for the claims and requested relief in the notice during this 60-day period, and during any agreed extension of that period. F. Beginning arbitration. Information about arbitration and how to start one is available at ard.org/support and directv.com/arbitration-information. You must send a copy of your arbitration demand to the address in Section 10D. Information required before beginning arbitration. You cannot begin arbitration if you skip any of the requirements of Sections 10D, information required before beginning arbitration, and 10E, time to resolve the claim. 1. Providing a notice with all required information. 2. Providing 60 days to assess your claim. And 3, if requested, personally participating in a call or video conference about resolving your claim. We also must follow these steps before bringing an arbitration against you. The party initiating arbitration and their counsel must provide a certification of compliance with these requirements to the American Arbitration Association, AAA, with the demand for arbitration. A court can enjoin the filing or prosecuting of an arbitration if any of these requirements aren't met. Unless prohibited by law, the arbitration provider shall not accept or administer arbitration unless these requirements are met. The party submitting the demand for arbitration and their counsel, if represented, certifies that they have complied with the requirements of Federal Rule of Civil Procedure 11b, including that the claim and relief sought is neither frivolous nor brought for an improper purpose. The arbitrator is authorized to impose all relief available under the AAA rules, defined below, Federal Rule of Civil Procedure 11, and applicable federal and state laws against represented parties and their counsel. G. Arbitration procedures. The arbitration will be governed by the then-current Consumer Arbitration Rules, AAA rules of the AAA, as modified by this Section 10, dispute resolution, and administered by the AAA. If the AAA can't or won't administer the arbitration in accordance with this Section 10, dispute resolution, will agree to another administrator or ask a court to pick one. If DIRECTV and you can't agree, that will do so. That determination is final, and you and we agree that neither a court nor an arbitrator shall have the authority to revisit it. Unless DIRECTV and you agree otherwise, any hearings will take place in the county or parish of your billing address. The arbitrator can award the same damages and relief that a court can award under applicable law. An arbitrator's ruling is not binding in any proceeding involving another customer. The arbitrator's award may be entered in any court having jurisdiction over the parties only if necessary for purposes of enforcing the arbitrator's award. An arbitrator's award that has been fully satisfied shall not be entered in any court. H. Arbitration fees. We will pay all costs of any arbitration we initiate. If you initiate arbitration, the AAA rules will govern payment unless applicable law requires a different allocation of fees for this arbitration provision to be enforceable. If you can't pay your share of the AAA fees, DIRECTV will consider a request to pay them for you. You or DIRECTV may engage with the AAA around fee reductions and deferred payments. You and DIRECTV agree that arbitration should be efficient and cost-effective for all parties. I. Individual relief, class action waiver, jury trial waiver. DIRECTV and you agree that each may bring or assert claims against the other only in your or its individual capacity and not as a plaintiff or class member in any purported class, representative, or private attorney general proceeding in arbitration and in court. The arbitrator may award relief, including damages, restitution, declaratory relief, and injunctive relief, only in favor of the individual party seeking relief and only the extent necessary to provide relief warranted by that party's individual claim. Further, unless DIRECTV and you agree otherwise, the arbitrator may not consolidate claims or preside over any form of representative, class, or private attorney general proceeding or otherwise award relief affecting other customers. If any of these prohibitions is unenforceable as to a particular claim or request for relief, for example, injunctive relief, then that claim or request for relief shall be decided by a court after all other claims are arbitrated. Notwithstanding the foregoing, DIRECTV and you retain the right to participate in a class-wide settlement. To the maximum extent permitted by law, DIRECTV and you waive the right to a jury trial. J. Resolving mass arbitration filings. If 25 or more claimants submit notices raising similar claims and are represented by the same or coordinated counsel and seek to file arbitrations, and you are one of the claimants, you agree to this stage process. You agree to this process by choosing to participate in a mass arbitration and understand that the adjudication of your claim might be delayed and ultimately proceed in court. In the first stage, each side shall select 50 cases, 100 cases total, to be filed in arbitration and resolved individually by different arbitrators selected in accordance with Section 10G, arbitration procedures. In the meantime, no other cases may be filed in arbitration, and the AAA shall not accept, administer, or demand payment of fees for arbitrations commenced in violation of this Section 10J, resolving mass arbitration filings. If there are fewer than 100 cases total, then all shall proceed individually. If a case is withdrawn prior to the issuance of an arbitration award, then another claim shall be selected to proceed in its place as part of this stage. The arbitrators are encouraged to resolve the cases as swiftly as possible, consistent with fairness to the parties. After the conclusion of the first stage of 100 arbitrations, both sides will participate in a global mediation session of all remaining claims with a retired federal or state court judge, and we will pay the mediator's fee. If the parties can't agree how to resolve the remaining claims after the conclusion of the first stage of proceedings and mediation, the process will be repeated consistent with the parameters set forth above. With a second stage of 100 cases per side, 200 cases total, to be filed in arbitration and resolved individually by different arbitrators selected in accordance with Section 10G, arbitration procedures. If a case is withdrawn prior to the issuance of an arbitration award, then another claim shall be selected to proceed in its place as part of this stage. After the conclusion of this second stage of 200 arbitrations, both sides will participate in a second global mediation session of all remaining claims with a retired federal or state court judge, and we will again pay the mediator's fee. If any claims remain after the second stage mediation, each remaining claim shall be opted out of arbitration and may only proceed in a court of competent jurisdiction consistent with the remainder of this agreement, including Section 10I. Individual relief, class action waiver, jury trial waiver. Notwithstanding the foregoing, counsel for the parties may mutually agree in writing to proceed with the adjudication of some or all the remaining claims in individual arbitrations consistent with the second stage process. Except cases shall be randomly selected and mediation shall be elective by agreement of counsel for the parties, or through another mutually agreeable process. If this Section 10J, resolving mass arbitration filings, applies to a notice, any statute of limitations applicable to the claims set forth in that notice will be told from the time the first cases are selected for stage proceedings until that notice is selected for a stage proceeding, withdrawn, opted out of arbitration, or otherwise resolved. A court will have the authority to enforce this Section 10J, resolving mass arbitration filings, including by enjoining the mass filing, prosecution, or administration of arbitrations or the assessment or collection of AAA fees. Section 10J, resolving mass arbitration filings, and each of its requirements are essential parts of this arbitration provision. If, after exhaustion of all appeals, a court of competent jurisdiction decides that Section 10J, resolving mass arbitration filings, applies to your claim and is not enforceable, then your claim shall not proceed in arbitration and shall only proceed in a court of competent jurisdiction consistent with the remainder of the agreement, including Section 10I, individual relief, class action waiver, jury trial waiver. K. If DIRECTV changes this arbitration provision, you may reject any changes we may make to Section 10, dispute resolution, by sending written notice within 30 days of your first notice of changes to the address provided above in Section 10D, information required before beginning arbitration. Your written notice must include your name, email and physical address, phone number, account number, and a statement personally signed by you that you wish to reject the changes to Section 10, dispute resolution. This is not a rejection of arbitration altogether. If you reject future changes, you agree to arbitrate under this provision. Section 11. Disclaimer of warranties. You acknowledge and agree that the app and service, including all content contained therein or accessed thereby, as provided on and as is and as available basis, and that your use of or reliance upon the app and service is at your sole risk and discretion. To the extent not prohibited by law, DIRECTV and its collaborators, suppliers, and licensors hereby disclaim any and all representations, warranties, and guarantees regarding the app and service, whether oral, express, implied, or statutory, and whether arising by law, statute, usage of trade, custom, course of dealing, or performance of the parties, or the nature or context of this agreement, and including, without limitation, the implied warranties of merchantability, fitness for a particular purpose, and non-infringement. Furthermore, DIRECTV and its collaborators, suppliers, and licensors make no warranty that 1. The app or service will meet your requirements. 2. The app or service will be uninterrupted, accurate, reliable, timely, secure, free from viruses or other harmful components, or error-free. 3. The quality of any products, services, information, or other material accessed or obtained by you through the app or service will be as represented or meet your expectations. Or 4. Any errors in the app or service will be corrected, or that the app or service will be maintained. You acknowledge that the app is not intended or suitable for use in situations or environments where the performance of, use or misuse of, failure of, or errors or inaccuracies in the content, data, or information provided by the app could lead to death, personal injury, or severe physical, property, or environmental damage. DIRECTV and its collaborators, suppliers, and licensors do not warrant that the app or service will be compatible or interoperable with your device or any other piece of hardware, software, equipment, or device installed on or used in connection with your device. Furthermore, you acknowledge that compatibility and interoperability problems can cause the performance of your device to diminish or fail completely, and may result in permanent damage to your device, loss of the data located on your device, and corruption of the software and files located on your device. You acknowledge and agree that DIRECTV and its collaborators, suppliers, and licensors, and their officers, directors, employees, and agents shall have no liability to you for any losses suffered, resulting from or arising in connection with compatibility or interoperability problems. Should the app prove defective, you assume the entire burden of all necessary expenses, servicing, repair, or correction. This Section 11 shall survive termination of this agreement. Section 12. Limitation of liability. Except to the extent prohibited by law, under no circumstances shall DIRECTV, its collaborators, suppliers, or licensors, nor their officers, directors, employees, and agents be liable for accidents, property damage, personal injury, death, or for any indirect, incidental, consequential, punitive, special, or exemplary damages arising out of, or in connection with, or relating to the sale or distribution of, the performance or non-performance, or your access or use of or inability to access or use the app or service, whether or not the damages were foreseeable and whether or not such party was advised of the possibility of such damages. Without limiting the generality of the foregoing, DIRECTV's aggregate liability to you, whether under contract, tort, statute, or otherwise, shall not exceed the greater of 1. The fee you paid for your initial month's subscription to the service. 2. The aggregate amount you paid to DIRECTV for the service during the 1 month preceding the date that the claim arises, or 3. $2. The foregoing limitations will apply even if the above-stated remedy fails of its essential purpose. This Section 12 shall survive termination of this agreement. Section 13. Indemnification. You shall indemnify, defend, and hold harmless DIRECTV and its collaborators, suppliers, and licensors, and their officers, directors, agents, and employees, the indemnified parties from and against any claim, proceeding, loss, damage, fine, penalty, interest, and expense, including, without limitation, fees for attorneys and other professional advisors, arising out of, in connection with or related to the following. 1. Your access to, or use of the app, service, or third-party content and services. 2. Your breach of this agreement. 3. Your violation of law. 4. Your negligence or willful misconduct. Or 5. Your violation of the rights of a third party. You will promptly notify DIRECTV in writing of any third-party claim arising out of or in connection with your access to or use of the app or service. These obligations survive termination of this agreement. Section 14. Miscellaneous. The following provisions survive termination of this agreement. Section 14.1. Governing law, limitation on actions. This agreement shall be deemed to take place in the state of New York and shall be governed by and construed in accordance with the laws of the state of New York, excluding its conflicts of law principles. This agreement shall not be governed by the United Nations Convention on Contracts for the International Sale of Goods, the application of which is expressly excluded. To the maximum extent permitted by applicable law, you and DIRECTV agree that any cause of action arising out of or relating to this agreement, the app, the service, or your use of the app or service must commence within 1 year after the applicable cause of action accrues in accordance with the dispute resolution provision. Otherwise, such cause of action is permanently barred. Section 14.2. Contact information. You may reach our customer service department about your service by calling 1-833-622-0198 to speak to a representative. Section 14.3. Electronic communications. We may communicate with you about the service and this agreement via email to the email address registered with your service account. You hereby consent to receive those communications and agree that any communications we send to you electronically to the email address registered with your service account will satisfy any applicable legal notice requirement. It is your responsibility to notify us of any changes to your email address, and we shall have no liability resulting from your failure to receive any communication sent to the email address registered with your service account unless we receive written notice from you of a change to your email address. Section 14.4. Severability. If any provision of this agreement is held to be invalid or unenforceable, the remaining provisions shall not be affected and shall remain valid and enforceable to the fullest extent permitted by law. Section 14.5. Waiver. Except as provided herein. The failure to exercise a right or require performance of an obligation under this agreement shall not affect a party's ability to exercise such right or require such performance at any time thereafter, nor shall the waiver of a breach constitute waiver of any subsequent breach. Section 14.7. U.S. Government use. The app and its related documentation are commercial items, as that term is defined at 48 CFR Section 2.101, consisting of commercial computer software and commercial computer software documentation. As such terms are used in 48 CFR Section 12.212 or 48 CFR Section 227.7202 as applicable. Consistent with 48 CFR Section 12.212 or 48 CFR Section 227.7202-1 through 227.7202-4 as applicable. The commercial computer software and commercial computer software documentation are being licensed to U.S. government end users, A, only as commercial items, and B, with only those rights as are granted to all other end users pursuant to the terms and conditions herein. Section 14.8. Performance or benchmark testing. You may not disclose the results of any benchmark test using the app to any third party without DIRECTV's prior written approval. Section 14.9. Modification or amendment. To the extent not prohibited by law, DIRECTV may modify or amend the terms of this agreement at any time, with or without direct notice to you, by posting a copy of the modified or amended agreement available through the app and at DIRECTV.com. You will be deemed to have agreed to any such modification or amendment by your decision to continue using the app following the date in which the modified or amended agreement is made available through the app, DIRECTV.com. Section 14.10. Survival. Any provisions of this agreement which by their express language or by their context are intended to survive the termination of this agreement shall survive such termination. Section 14.11. Third-party beneficiaries. Except as explicitly provided in this agreement or in its incorporated agreements, nothing contained in this agreement is intended or shall be construed to confer upon any person, other than the parties hereto, any rights, benefits or remedies of any kind or character, or to create any obligations or liabilities of a party to any such person. Section 14.12. No transfer by you. You may not transfer your rights or obligations under this agreement. Any attempted transfer by you in contravention of this agreement shall be null and void. DIRECTV may assign this agreement without restriction. Section 14.13. DMCA copyright notifications. You may send a valid notification of claimed copyright infringement under the Digital Millennium Copyright Act, DMCA. Our designated agent to receive notifications of claimed infringement as described in DMCA subsection 512C3 is Manager of Security and Copyright Infringement. 1800 Perimeter Park Drive, Suite 100. Morrisville, North Carolina, 27560. Email copyright@att.com. For further information, see att.com/legal/terms.dmca.html. Section 14.14. Entire agreement. This agreement, including the documents incorporated herein by reference, constitute the entire agreement with respect to the use of the app and service and supersedes all prior or contemporaneous understandings regarding such subject matter. Third-party terms. Open source terms. The app may use, incorporate, or access software that is subject to the following open source license terms. Copyright joined, incorporated, and other node contributors. Permission is hereby granted, free of charge, to any person obtaining a copy of this software and associated documentation files, the software, to deal in the software without restriction, including without limitation the rights to use, copy, modify, merge, publish, distribute, sublicense, and or sell copies of the software, and to permit persons to whom the software is furnished to do so, subject to the following conditions. The above copyright notice and this permission notice shall be included in all copies or substantial portions of the software. The software is provided as is, without warranty of any kind, express or implied, including but not limited to the warranties of merchantability, fitness for a particular purpose, and non-infringement. In no event shall the authors or copyright holders be liable for any claim, damages, or other liability, whether in an action of contract, tort, or otherwise, arising from, out of, or in connection with the software or the use or other dealings in the software. This has been a reading of the DIRECTV Stream Terms of Service and End User License Agreement, effective as of November 7, 2023, until replaced. A link to the full text can be found in the video's description. Feel free to like, comment, and subscribe for more videos. Thanks for watching, and have a nice day.